It's really important when a client is coming to me that I establish whether they own the property with their partner or not, because that's a real consideration about how the property might be divided if there's either a separation or a death. Now, in the event of separation, if a client was to come to me and say their partner had separated and the property was in their sole name 100% and they had no interest in the property, then that puts the client at real risk that they might not receive anything from that property at all, even if they had been living together as if they were married and husband and wife. Unfortunately, the law does not apply in respect of divorce for cohabitees, and they don't have the same protections. What I would be doing is firstly asking if there's a declaration of trust in place or a cohabitation agreement, but if neither of those documents are in place, then unfortunately it's a risk that potentially there's no money to come back to that person. It's important to get legal advice. There's potential for negotiations depending on whether there had been money put into the property and the intentions of the parties. Unfortunately, it's not a straight yes or no answer, and it's really important that people do get legal advice. And if you're in a situation where you're currently living with your partner and they own the property and you think that you do have a right in the property, get some legal advice now about that, because it's really important that that's clarified. And if your partner is happy to have a percentage, that is set in stone and put in writing, because it will give you protection in the long run.